employee health, where they are saying allow only 50% of the employees to come in, try to have 14 days quarantine, etc., etc. All these advisories are coming in, right? So one company wants to now take sort of some specific action to protect the employees. So it basically asks all the employees now to disclose their travel history, not only their own travel history, but also travel history of the people that they regularly come in touch with, and also whether these individuals who they regularly come in touch with have any signs of the illness that we are talking about, and uh, and whether there are medical tests that have been conducted, and whether those tests should be shared with the company to ensure that no further care needs to be taken vis-a-vis the attendance of that employee in the office. It's the longest proposition I've stated, but it is important to understand these type of scenarios. And in this context, under the current law, I want you to first focus on the current law as to what type of processes need to be put in place quickly to undertake this entire process.
Thank you, Gowree. So this fact pattern, is actually quite common with what a lot of companies are doing today.
You need to speak a little louder. You're not audible.
Sure. So thank you, Gowree. So this fact pattern is quite common with what companies and organizations are doing today. With respect to their employees, with respect to visitors on their premises on campus, and with respect to people with whom their employees come in contact with. A lot of companies are adopting these measures, and we have been addressing various queries on this particular point as well. Just wanted to recheck, am I audible now?
Speak louder, that's all. Please speak.
Okay, sure. So essentially, I think it's important to understand how this is treated under the current law, before going anywhere else. So the current framework that we had, Gowree mentioned that we have an IT Act under which we have certain rules from 2011. But firstly, we need to understand what kind of data is first regulated today, what kind of data is aimed to be protected, before we go to this fact specific scenario to see what such organizations may need to do vis-a-vis its employees and vis-a-vis other people with whom their employees come in contact with. So today, information such as travel history, for instance, information such as travel history today may be treated as personal data. So personal data is essentially any information that may independently or in combination with other data identify an individual, right? It could be their name, phone number, certain attributes about them, location details, which we'll go into a little later in this webinar, and travel history, right? And should be construed one of these types of data as well. You also have medical data. So you also have, for instance, temperatures being taken from employees. Now this may constitute medical data or health related data under the law, right? Because um, sensitive personal data today is defined as certain data of which medical records and history is included, um, as well as physiological, and mental health conditions are also included as sensitive data. Now, what happens if organizations are collecting such types of information from employees, right? So if they are from employees, we first need to see if it merely constitutes personal data, say for instance, travel history, then specific compliances like a consent, like a notice, and certain disclosures may not be relevant. Today, under current law, it's important to note there are no specific compliances for collection and use of one's personal data. But the moment certain medical data is collected, even recording a temperature, certain medical records over the past few days of employees, the moment that kind of information is collected by an employer, by an organization, then consents need to be taken. The compliances such as disclosures, how they are going to process that, what they are going to use that data for, how long they are going to retain that data for. Are they going to disclose it or transfer it to any third party like a hospital, a clinic, a diagnostic lab? These are the kind of things that typically would need to be disclosed to the employee. So this is just, a broad difference. It's important to note, one more thing. Under current law today, the current law, that is the IT Act, these compliances are only applicable if this kind of data is over electronic form, is collected by electronic form, right? So if you have, I mean, I'm sure we'll get into this a little later, maybe a housing society collecting certain data, or, in other forms, which is not electronic form, then these compliances shouldn't even apply today, because the law is, fairly restricted to sensitive data, which is recorded or stored in electronic form. I just want to spend one more minute here on CCTV cameras, because we spoke about surveillance. So often organizations, and we are asked as well, whether CCTV cameras can be used to see, anybody entering the premises, people's whereabouts, where they are going inside the premises, and what they are doing, including for other purposes like internal security and the like. Again, CCTV cameras are not separately regulated. They are, there's no separate law applicable to use of CCTV cameras. They largely fall under the domain of the IT Act, and the compliances. Data, if not analyzed, if biometrics are not taken, if recordings are not analyzed, if it is for merely for surveillance and imaging purposes to view activities, then that should merely constitute personal data. And again, no, compliances should not be triggered. Having said that, our right to privacy judgment, which we'll elaborate a little later on, also does, ponder on the point that it should be in places where there is no expectation of privacy, and in more or less public areas. Certain states, certain localities and municipalities have laws for organizations when implementing CCTV cameras. For example, in Navi Mumbai, there's a self-regulation code for organizations to follow when implementing CCTV cameras. But again, it's largely treated on par with personal data and sensitive personal data under the current law.
Thanks, Aaron. So one interesting thing, that also comes up, that when I mentioned about if I have to collect information not only of the employees, but people who are associated with the employees. So there the question arises that whose consent can be taken, because the organization is not directly in touch with the, third parties, right? So in these type of situation, the question arises whether then the employee is required to separately go and take consent of the people from whom the data is collected and then pass it on to the organization. Can it be, that process be simplified? So these are issues that arise. And ultimately, in these type of dire situations, sometimes one could probably go ahead and take a more pragmatic and proactive approach than, getting into nitty-gritties, because when you have thousands and thousands of employees, it may not really be possible to, achieve all of that, right? So I think that is, that's more on a practical level. We were noticing, some of the queries that came in. But if you go under the new law, right, which is the Data Protection Bill, there is a specific exclusion provided, right, from consent. Now, under the current law, you don't have exclusions, and therefore we had to, sort of provide to the organization that that you have to, go and take consent specifically. But the new law has exclusions. So can you explain exclusions quickly, and then also deliberate whether you believe those exclusions really apply in the current scheme of things or they don't when a private organization is collecting that data?
Sure, Gowree. Um, so that's a very, good point. We have the new law, which is in under parliamentary consideration at the moment, and we've done separate talks on that as well. So we won't go into the background and where it stands, but we do know that it is around the corner in a few months. Now, under the new law, there are it is different, to start with, in terms of how both types of data that I mentioned are regulated. So even personal data, which is not currently regulated or specifically protected under the law, let me say, that as well as sensitive data is also protected under the law. So hence, even an organization collecting personal data will need to implement various compliances. The compliances, without going into detail, and I won't go into detail, are very
No,
GDPR.
Aaron, let's just focus on the exclusions rather than compliances for now.
Yeah, sure. So I was just coming to that. So the exclusions, to the consent and notice requirements, which are there currently for both personal and sensitive data, there are certain exclusions which involve, for instance, responding to a medical emergency, which involves a threat to life of an individual. Now, this is very specific again, and this is where there is already an emergency and where a response needs to be given, right? It is not maybe to detect an illness or to diagnose somebody, right? There is another exception to undertake a measure to provide medical treatment or health services to an individual during an epidemic or an outbreak of a disease. Now, again, this seems to be a wide exception, but often when detection happens, maybe at an organizational level, or even airlines have been, doing this test on passengers, it is not to provide medical treatment per se, right? It is more of a detection mechanism. So again, this could be worded better. When we see a next version to cover these kind of instances that we have today, it's a good learning curve for us. There is also one more exemption, which is to ensure the safety or provide assistance or services to an individual during the time of any disaster or breakdown of public order. Again, this has a high threshold because there has to be a disaster which is in place or a breakdown of public order. And then you are doing this only to ensure their safety, right? So these kind of specific medical related exemptions we feel are not, wide enough maybe to cover today's day and age where organizations, need to test employees, airlines need to test passengers and the like. Specifically, I want to spend 20 seconds on, in the employment scenario, there are relaxations and exemptions in an employee-employer relationship where consent is not required. Unfortunately, that has no extension to any medical related purposes. So that is more for things like appraisal, recruitment, termination, and that. So by virtue of being an employer, an organization cannot even take benefit of this kind of an exemption, right? Um, Going to there are some more general exemptions now, based on which certain data like temperature taking, certain medical tests and all can be taken, and companies have been doing so. The overall purpose where it is in overall public interest, um, where there is um, where there is no expectation or no reasonable expectation of an individual to take consent, or whether the individual's safety is important, and whether taking that consent is not reasonable in the first place, right? Like when you have somebody entering your premises, an organization may not be able to show a notice and take consent on the spot, right? Or a passenger entering or leaving an airport. It is not reasonable to take consent, and the overall purpose of doing this is in public safety, right? So today, we have these provisions for organizations to go under overall public interest and safety, where you need not always take consent because it's impracticable. But we would want to see the revised version of the law a little more broad to cover, you know, today's scenario where these kind of detections need to happen for the overall public benefit and detection.
I think that's a fair point because ultimately, only when the law is tested, do you realize that, these enabling provisions are required both at the organization level, which is a private organization, and the government level, right? The point that Aaron covered very well, earlier on CCTV or temperature taking and all these scenarios, at least prima facie reading may not be necessarily adequately covered as exclusions, and these are the situations where you really can't be taking consents. The real issue arises is whether when a temperature is being taken, as you can see in most of the buildings now, the temperature is being taken. Now whether the question arises whether that is a personal information in the first place, because nobody's identifying you really, right? And therefore, and no, that information is not getting stored. So the Data Protection Act per se may not necessarily apply because there is no identifiable information, but whether overarching concept of privacy will apply. Those are the things more on a on a on a philosophical level. But yes, ultimately you have to balance things out, and that's where I want to come to Jaideep. When we talk about balancing things out, we saw in 2017 we recognized the right to privacy. And the reason I'm jumping to right to privacy now from data protection law is the reason is that for the audience here, to simplify the privacy, the right to privacy that was recognized, that right is available for individuals vis-a-vis the state action, that is the government action. Whereas the data protection law under the IT Act and the proposed Data Protection Act, it also applies to the private bodies, also applies to, of course, the government, but mainly to the private bodies as well. So in that context, if you really see where did the right of privacy fit in under the law by the Supreme Court, it was fitted under the right to life, which is Article 21. And then the question arises, whatever is being done now is in fact to protect our lives, right? To whatever steps are being taken, the data collected or otherwise, right? So the balancing act. Now, where is that balancing act? Whether it is a balancing act or not, when the government is doing this surveillance, as you must have seen. So Jaideep is going to first elucidate as to what are the various measures the government has taken, and then sort of jump into to demonstrate whether we believe that those actions are exempt or rather are appropriate in the light of the right to privacy that all of us have. So over to you, Jaideep.
Sure. Thanks, Gowree. So as Gowree was saying, the question is on the right of individuals, their privacy rights vis-a-vis the state. Now, when we look at these actions broadly, we can divide them into central government actions and state government actions. Largely, the data collection, as far as some of the public sources show, is by the state governments. Some of the measures seen are, for instance, the Telangana government and the Delhi government collecting location data. There was also a measure by the Karnataka government requiring people in quarantine to upload one selfie per hour, and the selfie would be tagged with the location of the mobile phone, therefore giving comfort to the police that the person is still in quarantine. Another measure by the Bangalore police was to put out the address information of people who are in quarantine without identifying them. So these are some examples. There are many others by other states. The question arises on whether this is too drastic an infringement of an individual's privacy, because especially when I read about the one selfie per hour scheme, that's the first thing that comes to your mind, because this is the state forcing you to do something. Interestingly, the Puttaswamy judgment, which was a 9-judge decision of the Supreme Court, the leading opinion in that judgment by Justice Chandrachud specifically envisaged the situation of an epidemic disease. It didn't discuss it in very much detail, but it did contain some discussion about it. The broad test from a wider perspective that the judgment laid down is that whenever the state has to impinge upon the right to privacy, there's a threefold test. The first test is on, the first element of the test is on legality. So the action has to be backed by a duly promulgated law. The second element is on the state interest. So there has to be a legitimate state interest. And in the case of a global pandemic like this, it's quite easy to prove that there is a very valid state interest. The third element is that the action has to be proportionate to that interest. It shouldn't be excessive. If there's a less invasive measure, a less invasive measure should be taken. So this is the test based on which all state infringements of privacy, or rather impinging on privacy, will be tested. Now, when one looks at this, one also has to see the variety of laws available to the state based on which they can take some of these actions. Some of them are the Information Technology Act, where information stored on any computer resource can be requested. The Telegraph Act, which is a parallel provision with regard to telecom data. The Epidemic Diseases Act, which not a lot of people were aware of, it's an act of 1897, but which gives wide powers to the state government to take any measures in connection with an epidemic disease. And the Code of Criminal Procedure, which has a provision where authorities can request for data in connection with any investigation. So broadly speaking, all of these enabling legislations allow the state to take some of these apparently privacy invasive actions. And they fulfill the test of legality, which is the first test laid down by the Puttaswamy case. They are also likely to fulfill the second element, which is the state interest element, because of the scale of the pandemic. The third test is something which is likely to be a little more controversial, whether some of these actions are excessive or not. But given the scale and given that this is an unprecedented situation, possibly for say 100 years or so, courts would seem to be our gut is that courts would seem to give a longer rope to authorities to take measures that they deem necessary to prevent this outbreak. But what would really fall in the gap or fall between the cracks is any measure that is not backed by a law. So if there is some kind of data collection taking place by the state which is not backed by a law, possibly one may say that the mere plenary power which is available to the state is not enough, because the Puttaswamy judgment expressly lays down that all these actions need to be backed by a law.
Thanks, Jaideep, for that, sort of clear, sort of presentation of the issue in a simple manner, because these are complex issues. And whenever we need to balance the right of the individual versus the right of the public, right? In these type of situations, as you rightly said, there is definitely a possibility of court, balance, looking at that balance in a reasonable manner. But yes, the questions do arise whether there is a backing of law. For example, this tracking of the, of the mobiles by GPS, right? Whether a proper order by following due process of law has been issued. So there is that in between step, that where you do have a power, but you need to follow due process of law. Whether that process has been followed or not, honestly, I'm not sure whether people are really worried on that count and want to really challenge that, unless, as you rightly said, it is absolutely excessive, right? And in these type of situations, what is excessive is a question mark, because anything that you seem to do seems to fall short in terms of controlling the situation, right? Now, coming, Aaron, quickly to you, and this is slightly digressing from the earlier point, but equally important, is a cross-border data flow. What we also are noticing is that there is a possibility of, the medical fraternity wanting, support from other jurisdictions, and for that reason requiring to transfer medical data, from India. And that, assuming, I'm just putting a case scenario, assume that it's an identifiable information and not an anonymized information. So is it allowed under the current law? Number one, just, you can just say yes or no, and then more focused on the new law that is coming in, whether we believe that that will become a hurdle, if at all, under the new law. Aaron, please unmute yourself.
There is it is allowed, Gowree, under the current law. It is a very simple compliance, irrespective of whether an organization or a state agency needs to transfer medical data overseas. It can be done subject to a compliance, that certain data protection measures are undertaken by the data recipient. Also, there is no specific localization requirement today for medical data. I think that's an important point as well. It was proposed, in Disha, but that hasn't come in, so there is no specific requirement to only store it in India. Coming to the proposed law, um, it is again allowed to be transferred. One can do so, but under most stringent circumstances. So the medical data will be construed as sensitive data. Sensitive data can then only be transferred overseas if the data protection authority, not yet set up, but to be set up under the proposed law, if the data protection authority approves the transfer for a specific purpose, or approves a particular contract in place, or if the central government directly were to approve a particular organization or a class of organizations or a region to which the data can be transferred. So the two most likely scenarios is where the authority approves it for a specific purpose, like in the case of an emergency or for R&D testing, and the like, or whether or when the government permits it to a particular organization, or maybe for a similar purpose. So one more thing.
Yeah, to
One more
summarize,
thing, if
sorry, go ahead. I noticed.
sorry, this is one more concept of critical personal data which we don't have clarity on today. If by chance tomorrow, once the law comes in, such data would be classified as critical personal data, there is a relaxation for the critical personal data to also be transferred overseas in the case of medical emergencies or for medical purposes.
Sure. So you believe that the proposed law also takes into account the situation insofar as the data transfer also is concerned, and maybe but maybe a good idea to revisit in these type of situations. Now I'm just again coming back to you, Jaideep. One quick question. Today we saw a very interesting app being introduced by the government called Arogya Setu, where maybe we'll have to repeat a couple of points, but which is very interesting. Where you can just explain how the app works and what do you see in terms of the law. How do you see the compliance is shaping up for that very quickly?
Sure, sure. So the high-level understanding of the app, and we can examine it in more detail, is that it tracks a user's location to determine whether they have been near any confirmed cases of COVID-19. And if they have been, based on the location, the app sends a warning to the user, noting, for instance, that you've been in a high-risk area and you should get tested. They may also send that information to the appropriate authorities who may contact the user, because we've noticed that the authorities have been proactive in carrying out what is called contact tracing. That is, people who have come in contact with confirmed cases of COVID. Interestingly, the app has a privacy policy. So to the extent that users may have expressly consented to the ways in which the app is sharing the information, that itself eases a lot of the burden of the state because they have got the consent. It's not immediately clear under which law exactly this app is being released, but if it's a consent-based system, some of those tests may fall away, and it may become a little easier for the app to work.
Yeah, thanks. Because I was also examining two separate laws, the Epidemic Act, as you had pointed out earlier, and the other one is the Disaster Management Act, right? And if you see the Disaster Management Act, it gives wide powers to the government to come up with a plan, etc., right? And this entire thing, the setup or the entire planning that the government is doing, if you saw today, even Prime Minister Modi was sort of talking to all the chief ministers of the all the states, and arriving at certain action plans, right? So all these things that are being taken probably, and they have issued a notification under the Disaster Management Act, right? So probably some of these will get backed by this, but a very valid point by you that if it is consent based, then most of the issues go away technically. And here, interestingly, again, as a responsible citizen, whether I want to sort of, put myself out there to say that, yes, I have a problem, in this particular area. So, then I'm opening myself up to the app to say that, let others be careful if they have been around me, right? So it is more of that responsibility behavior, if at all, by the individuals vis-a-vis the community, right? So sometimes law, yes, very important how the law fares, but ultimately, are you a responsible citizen also comes into play in that context. But interestingly, if you really see, you don't really see names. The media also has been somewhat cautious. You really don't see names of individuals being reported in the number of cases that have been reported, except probably some celebrities, etc., that we saw. But what they are really doing is cordoning off the areas in a selective manner, to sort of protect, the people around, and then they are doing those testings, right? So you don't really see, like a list of people or anything of that sort. And there was a discussion for and against, in relation to that. So if you there have been a couple of judgments, and which have been noted in Puttaswamy, to say that if a name of the individual, or this was in the context of HIV, right, disease, and in case of HIV also, it is equally, important that the others are aware, sometimes, especially the wife and all these things, right, or a would-be wife. So in one of the cases, they said, probably a would-be wife has a right to know. So it is always in a contextual thing that we need to see, whether or not a certain information needs to be disclosed, right? So I'm going to just now, stop the privacy related discussion here, but now go to the intermediary point, because that is turning out to be equally important, especially after couple of advisories issued by the central government as well as the Supreme Court government. So maybe, Jaideep, will you be taking that question and sort of addressing as to what we have seen in that context?
Sure, sure. So, interestingly, just as a side note, there have been around 800 advisories last I checked. When I say advisories, I'm including notifications, orders, circulars, memos, etc., related to COVID by various departments. Some organizations have helpfully collected these, like PRS, etc. So there's a huge body of legal material coming out with regard to COVID. Some of the things regarding social media and intermediaries, with a particular focus on fake news, are an advisory by the Ministry of Electronics and Information Technology, MeitY, which put out this advisory to intermediaries, and especially social media platforms, that they need to be vigilant with regard to fake news which may spread panic, and immediately disable access to such content, and also make available the official version of events. So these obligations were there to an extent under the existing law, but this is a specific advisory issued in the wake of the current situation. The Ministry of Information and Broadcasting has put out another document requiring press to continue their services without disruption, which also would act as an enabler to probably ensure that media persons and their supporting infrastructure is not disrupted as a result of the lockdown, so that information can be disseminated easily and widely. The most recent and quite significant development was the Supreme Court order on the issue of migrant labor and their difficulties. So this was a PIL filed by an advocate in public interest. And while hearing the matter, the court noted the steps taken by the central government, and found that there may be fake news circulating on traditional media and social media. Possibly after being apprised of the facts by the government, it may have found some discrepancies between the media versions and the facts presented by the government. So it made certain observations, requiring media outlets to publish the official version of events, while also trying to be cautious that it did not want to impinge on free discussion about the pandemic. It also directed the government to put out its official version of events within 24 hours. So that has been implemented. And the Press Information Bureau has committed to publish a daily bulletin of the official version of events with regard to COVID. And I think today's bulletin came out a few hours ago. You can find it on the PIB website. So there has been some discussion on whether these directions by the court um, lean towards kind of directing the media to report events in a certain way. But again, the circumstances are extraordinary, so we'll have to see what kind of impact it has. They're also not framed as uh, iron cast directions. There is luckily a line allowing, expressly recognizing that they do not want to interfere with free discussion about events.
Sure. So I'm going to come back to you on this particular point, Jaideep, in a bit. But Aaron, a couple of quick questions to you, and maybe Jaideep, and then you can just look at the questions that have come from from the audience. So Aaron, we also have another committee in India looking at non-personal data, right? In the context of the current situation where anonymized data now whether should be shared, because the committee is looking at the issue whether the company or the private bodies should be asked to share the anonymized data with the government for certain purposes. So can you just shed some light on that? As also, in this type of situations, how do you believe that anonymized data sharing could, assist the government?
Sure. Thanks, Gowree. So, a committee of experts were, constituted back in September of last year to look primarily into the economic aspect of non-personal data. In the one-page memo by the government, they classified, this kind of data as having high economic importance, but also being a very important public resource and natural resource, basis which, if used correctly, um, decisions can be made about a particular community. It can help in the overall delivery of public services. So these are some key things to note, in how the government is looking at this as well. Um, in fact, they also include, they term it as community data, which belongs largely to a community. It may also include aggregated data, derived data, anonymous data, and the like. But overall, the concept is that of community data. Now, in today's, in today's scheme of things, we're often hearing, in a particular locality, if somebody may have tested positive or if somebody is quarantined. So in today's demographics, especially in a country like ours, where the media and technology are playing a very big role, this kind of data is key in mitigating risks, in mitigating the spread of this kind of pandemic, right? What the committee can take into consideration, especially after an incident like this, is the importance of such data, right? Today, we are able to tell because of such data how fast, for instance, cases are rising in Maharashtra, right, versus say Karnataka. How certain congregations in certain parts of the country have increased the spread of this, right? How migrants, Jaideep spoke about migrants traveling from here to there. What are the age groups? How is this data spread, right? How many how many family members in a household? This is very important community data which needs to be used at a time like this to overall educate people, make them aware, and find out and prevent, the outspread of this, in emergency times like ours. So, this is something the committee should also look into, in terms of allowing government access to the data, allowing the data to perhaps be used by private organizations for a particular purpose, right, in terms of public safety or in emergency circumstances. But they need to look at this not only from an economic standpoint, but also from a social cause standpoint, because we don't have a better example than today in how important this data is for us.
No, that's very true. As I said at the beginning of the session, the current and proposed laws are actually getting tested in terms of their adequacy, in the current situation. So before Jaideep, you take a couple of questions, I'll answer the last question very quickly. both the proposed law and the present law both have a concept that the data needs to be cannot be used once the purpose for which it has been collected is discharged, right? So that's just to answer your question, Ishan, in brief. So in fact, under the proposed law, there is an explicit provision where a data subject, which is basically individuals, can go out and ask for specific deletion and erasure of the data. And there is a specific right being recognized in the proposed law. But even under the current law, there is a provision where you should retain the data only for the purpose for which it has been collected. So once the purpose is over, you should not be continuing to hold that data with you. So Jaideep, will you take a couple of questions that have come from the audience?
Sure, sure. I think the other question posed by Ishan was whether Indian government can come out with special orders or guidelines to protect the personal data of individuals being collected, and such special laws are being made across the globe, with Singapore and France being examples. So Ishan, the way I would look at it is it depends on the legal framework under which the government is purporting to collect the data. One thing that is quite clear, as I mentioned, is the government should not do so under a vacuum. It has to do so under a specific legal regime, whether it's the CRPC, whether it's the Epidemic Diseases Act, whether it's the Disaster Management Act, the IT Act, or the Telegraph Act. These are some of the legislative frameworks that come to mind. So when we talk about special orders or guidelines, some of these already contain detailed safeguards. For instance, the IT Act and the Telegraph Act already contain detailed safeguards with accompanying rules, and they've been interpreted by courts. So to that extent, there may not be a need to flesh those out in much greater detail due to COVID. But with regard to some of the less commonly used legislations like the Disaster Management Act, the Epidemic Diseases Act, and possibly police use of data under the CRPC, there can be guidelines framed, and I don't see an impediment to that. The court has also recognized in the recent order, the Supreme Court, that advisories do have a fair degree of force. So to the extent that there are gaps in the existing regime, it might be a good idea to make guidelines under the relevant legal framework. A broad omnibus set of guidelines may not be within the executive power of the government, though potentially they can do that as an advisory under the Disaster Management Act with special reference to COVID. Maybe I can also quickly touch upon the second one, unless Gowree, you want to add on this one.
Fine, please go ahead.
Okay, so the other question is from Frenny Patel on would stamping on hands be considered a violation of one's privacy if the new law were in place? So this depends on the data that's being collected. As far as I'm aware, at a high level, what it means is that that individual's address would be collected. Maybe some other details may also be collected, but largely the data protection framework would apply to the collection and processing of the data, say the address data or the health data of an individual. The act itself of stamping on the hands, it's a little difficult to say whether that by itself would be an infringement of privacy given the public interest involved and the other individual's right to a good public health environment. But definitely, if it's being done in an invasive or painful or harmful way, then potentially there's a claim that it might be too intrusive. But as of now, it's likely to be seen as a proportionate measure unless the data is misused in some way. And of course, the state is subject to the safeguards on how it's going to maintain the data of the quarantined individual.
Sure. So I think, Jaideep, I agree with you on the proportionality aspect because, as we said, when we see the Puttaswamy case of the Supreme Court, they actually have relied upon quite a few other cases, including of foreign jurisdictions, where they have balanced out the individual privacy versus public health, and then what sort of prevails, right? And the HIV example which I gave earlier was of a similar nature, where that identification was required, and therefore whenever you talk about the right to privacy, which, as I said before, comes within Article 21, which is right to life, and what you're really balancing out is a right to life of other community, or the community of people vis-a-vis that particular individual, right? And in the kind of situation that we are in today, so it's always a balancing act, and the proportionality is the key, as Jaideep said. And therefore, overall, the state action could, in situation, be held to be valid on this ground of balancing, on the ground of balancing of the rights of the parties involved. Now, coming to, probably we have, sort of couple of other points we may want to take at this point in time, and I'm again more on a, not so much on the legal issues, but more on the behavior of of the individuals as a community in this type of situation, both in the context of privacy and in the context of fake news. I thought I'll share a couple of thoughts here. The first point is, going back to the Arogya Setu app that we discussed earlier. As I said, that ultimately it is uh, the individual's responsibility as being a member of a community to protect the community from the harm, if at all likely to be posed by the presence of that individual in a social setting, right? So that, it's not something, from a legal perspective or otherwise, the law should be the last one to tell you that. You should be the first one to take those steps, right? So sometimes we think too much in the legal context, sometimes the ethical behavior as well, have to sort of prevail in my mind. Though I'm a lawyer, but sometimes you need to also think beyond law and think about ethics. And in this context, I believe ethical behavior is something that will be appreciated in these times. The second point on fake news, equally important for all of us to be cognizant, because I'm sure all of us receive so many forwards on our various messengers, uh, and and other social media platforms, that do this, do that, this is what is happening, etc., etc. Right? Just the kind of fear psychosis that we saw in Delhi, migrants, right? It was because of fake news, right? So I think, even as what we call as responsible netizens, it is our responsibility equally to only rely upon reliable sources and apply our mind before we just blindly, or sometimes one doesn't even read or open the link. I've seen those situations as well. So once again, a very responsible behavior is required, and I hope the Indian public really recognizes the importance of that, and all of us need to sort of hold on, sort of uh, our anxiety, and sort of have that control by not sharing unvalidated public information. And as Jaideep rightly pointed out, there are now the PIB, etc., are now actually circulating sort of official data points. So it is important to rely only on those official data points, because there was some discussion as well, and probably that itself is a fake news, that the government had sort of come out with a guideline that the administrators of some of the messenger groups, if there is fake news being circulated, the administrators will be held liable. Now that itself was fake news, it seems. But so ultimately, we should not let the government take those measures, but let, as a community, ourselves take those measures, and be a very, very responsible citizen. So we will stop here, and we will see if there are any additional questions. Otherwise, I think we have covered our points for tonight, and we'll be happy to take any questions offline as well. if the participants have any additional questions.